Please feel free to use Zoom's chat to share your thoughts and questions, because after the presentation, we will have time for Q&A. If you have a question for the speaker and you don't want to ask it yourself, please type it in the chat, preceded with a Q, so our moderators can identify them. Welcome to another talk on the Transceiver series organized by the New School Policy and Design for Outer Space. NSP2 is a chapter of SETS, Students for the Explorations and Development of Space, dedicated to investigating and advancing egalitarian ways of life as humanity extends beyond Earth. For this time, NSP2 is intersecting and cooperating with the Liberal Studies Student Association's project named Afro and Indigenous Futures. And this later project is another series of dialogues that started on April 2021, and whose purpose is to imagine the future from the perspectives of historically marginalized populations, so that indeed there can be a truly universal construction of images of the future for all humans and more than human beings. This time, we're excited to welcome Dr. Timiebi Aganaba. She's an assistant professor of space and society in the School for the Future of Innovation in Society, with a courtesy appointment at the Sandra Day O'Connor College of Law at the Arizona State University. She serves on the advisory board for the Space Generation Advisory Council, supporting the UN program on space application, and on the science advisory boards of Worldview Enterprises and the SETI Institute. She has previously served as the executive director of the World Space Week Association, as a space industry consultant, taught space policy, law, and economics at the International Space University, and represented Nigeria at the UN as a next generation aviation professional at the International Civil Aviation Organization Model Council in Montreal in 2014, and at the legal subcommittee of the Committee on the Peaceful Uses of Outer Space in Vienna in 2011. So without further ado, welcome, Dr. Aganaba. It's a pleasure to have you with us tonight. Please, the floor is yours.
Thank you so much. It is my pleasure to be here. I don't have any slides, so if you can just spotlight my video, that would be fantastic. I see a couple of friends in the audience, Rose, and a few new people, and it would be great to kind of find out, you know, just what people's interaction or interrelation is with the topic of space law and policy. So like, how comfortable do you feel with this topic? Because I'm gonna go quite in depth as to the evolution of this area of law. I was just talking with some of the hosts earlier on today and saying that space law is so dynamic because international law doesn't really change much and doesn't really move that fast. But in space, it's really a topic that in our lifetime, we will be able to influence the evolution of this area of law. So, you know, I would love to say, like, how comfortable do you feel with the topic of space law? If you're a complete beginner, put beginner in the chat. If you know something, put intermediate. And if you're gonna challenge me, put advanced. Can we do that in the chat? I see beginner, I see beginner. Okay, so the topic of this conversation, even though it's called the spirit and the, you know, either the spirit or the wording of the law, is really trying to say, how has using the case study and the topic of space resources, because we obviously envisage that we're going to be able to exploit the resources in space. What does that mean? How is international law speaking to that? And what is this relationship between international and national laws? So that's what we're going to be talking about today. I'm going to maybe talk for 30 minutes or so. Just going to talk. I've got no slides. I'm just going to talk to you. And then I would love to have a really engaging Q&A. And it's not necessarily questions. I would love your comments, because this paper that I'm presenting today is a work in progress. and is actually looking at how do we think about meaning, whether that's through treaty interpretation, or is it time for new innovative space governance instruments? So I'll go ahead and start. So one of the current and future issues in global space governance is on the legal status of space resources. And this matters because of the stated goal of various actors to find and use resources in space to further their mission, known as in situ resource use. So in a paper highlighted by Anderson et al., they talked about using space resources in space increases the longevity and decreases the cost of space exploration. So space mining, for instance, will likely begin with the extraction of water from the moon and accessible near-Earth asteroids. Hydrogen can be extracted from water to be used for jet fuel, and water can also be used for drinking and food production, as well as providing protection from radiation. But based on the terrestrial experience of mining as laid down by Anderson, an international mining company will consider various key issues when determining whether to proceed with a mining project. And the first one being the security of tenure. So can the mining company secure the legal rights to explore and develop the mining properties? Secondly, as at least 14 national space agencies have identified in situ resource use as a needed capability for long duration missions, it is apt to remember that self-interest in securing access to natural resources is at the root of many terrestrial disputes. So according to the former United Nations Secretary General, Ban Ki-moon, since 1990, at least 18 violent conflicts have been fueled by the exploitation of natural resources such as timber, minerals, oil, and gas. And sometimes this is caused by environmental damage and the marginalization of local populations who fail to benefit economically from natural resource exploitation. So without legal clarity and certainty, one cannot disregard the possibility that as well as stifling the development of the new in-space economy, future conflict or rivalry could arise due to the competition for these resources. Professor Deman highlights that the following conditions act as complicating factors. He talks about the fact that the applicable multilateral treaties are like international instruments, have been concluded a long time ago. They contain general and ambiguously phrased provisions that require subsequent agreement and practice for their clarification. They concern pioneering activities performed by or under control and supervision of a limited number of states, and they provide no apparent incentives among governments to pursue further action at the multilateral level. Now, in terms of general international law, there are two things to note here about what he says. That the age of a treaty doesn't necessarily impact its applicability. In fact, there are plenty of far older treaties that are interpreted today, like for instance, the Universal Postal Union, whose treaty enables us to send our mail. And secondly, in fact, in the grand scheme of things, 54 years for the space law regime isn't really that old at all. But Professor Deman also points out that the treaties are ambiguous. The issue then boils down to one of treaty interpretation, to which the Vienna Convention on the Law of Treaties speaks. The legal standards and rules for treaty interpretation are set out in Articles 31 and 32 of the Vienna Convention on the Law of Treaties, VCTLT. This piece of international law states that as well as taking into account subsequent agreement, practice, and meaning, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of the objects and purpose. Recourse may also be had to supplementary means of interpretation, including the preparatory works of the treaty and the circumstances of its conclusion, in essence, the historical records. So the Vienna Convention provides for ambiguity. That's exactly when we have to pull out the history rather than reinvent the wheel and define the provision ourselves. But according to Shikagara, sources of law should not end up as only technical lawyering mechanisms. Rather, they should chiefly be practical tools for enhancing states' mutual conduct in the pursuit of particular outcomes. As such, it is arguable that treaty law ought to allow the correction of any imperfections that become apparent in a treaty regime through subsequent state practice. In essence, treaty texts begin but do not end the process of lawmaking. So doctrine says we look at history, but also to look at subsequent practice. So what do we do when history and practice contradict? Here then we have to look at good faith. In this case, as indicating how the task of its interpretation is to be undertaken. So according to Gardner, good faith can be understood to have three aspects. First, good faith with regard to treaties requires reasonableness in both the interpretation and the performance of obligations. Secondly, good faith may demand a form of balancing rights and obligations such that a party does not act arbitrarily or abuse its rights. So one party to a treaty should not abuse its position or rights, even sovereign rights, but rather be fair and equitable as between the parties and not undertake actions calculated to procure an unfair advantage or to prejudice the interests of the other contracting parties. And finally, good faith requires interpreting a treaty so as to give effect to all its provisions rather than negating the effect of some provisions as a result of the interpretation of others. So the Artemis Lunar Exploration Program led by NASA aims to land the first woman and the next man on the moon by 2024. NASA sees Artemis as a key to the success of its moon to Mars exploration approach. And according to NASA, the Artemis program seeks to pave the way for a new and sustainable lunar economy. Therefore, commercial exploitation is foreseeable. Now, the US National Space Policy released on December 9th, 2020, clearly states that the United States will pursue the extraction and utilization of space resources in compliance with applicable law, recognizing that those resources as critical for sustainable exploration, scientific discovery, and commercial operations. The policy also highlights that as established in international law, outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. With this statement, Article 2 of the Outer Space Treaty, the so-called Constitution of Outer Space, is cited. And this reference makes clear that it aims to apply rather than complete the International Space Treaty framework. However, it is not internationally accepted that the United States' assertion of its rights to pursue space resources is in fact a legitimate legal right or in compliance with that provision of the Outer Space Treaty. Is the US acting in good faith? And is it even possible to truly do so, as there is no common understanding or ordinary meaning to space benefit and appropriation, and the dependence on legal interpretation on legal standards is relatively limited and superficial? As Greenberg argues, it is impossible to address the job of legal interpretation without addressing the central jurisprudential question of how the content of law is determined. This, of course, depends on who gets asked and who gets the say. Professor Durkee highlights that taking a critical approach to international law that observes treaty interpretation as a value-laden one, it is important to care about the process of interpretation in order to understand who is included in and excluded from the process of developing meaning, because understanding the process of interpretation is one way to excavate the levers of power. The important question, therefore, to ask is, how do contests of meaning take place? What levers of influence do they use? And what difference does all this make to the determination of law? I'd love to say that Chris Van Eyck today just posted an amazing chart that you can look at. You can check my Twitter at Timiebi 89 to see what we should be considering when treaty interpreting. But in this talk, I document the trend that advanced spacefaring states, pushed by their commercial representatives, are increasingly resorting to the adoption of domestic legislation that implements their international obligations according to an interpretation that best serves their own interests. The argument is that the approach accomplishes the goal of stimulating the space economy quicker and more efficiently than protracted multilateral negotiation processes that are cumbersome and unpredictable. So the United States in particular has taken an expansive approach, using multiple instruments and techniques, from actions taken at Congress to the executive branch, bilateral agreements at the agency level, to innovations in contracting, with the objective of to ensure its own certainty about its interpretation of international law and to sell its vision to and influence the international community. This matters because Article 31.3b of the Vienna Convention stipulates that there shall be taken into account, in addition to and together with other elements, any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. This subsequent practice is important because it is not clear that any of the methods of treaty interpretation speak to the immediate issue at hand. According to Brian Israel, the absence of a centralized authoritative mechanism for adjudicating divergent interpretations suggests that there will be more variability in national approaches than earlier governance eras. But the difference between what he calls constitutional multipolarity and regime destroying fragmentation is the degree of variability permitted. Despite these significant unilateral approaches, we must conclude that there is an important role for international law to backstop, strengthen, and compel domestic law and institutions to have the common interest in the foreground. This would ideally lead to a proliferation of national regimes that serve humankind as a whole, and eventually an international regime that solidifies the best practices from the implementation of those national practices. So what is the international landscape? During the Cold War, the specific details of commercial exploitation of natural resources of outer space was beyond the immediate codification objectives of the United States negotiators of the Constitution of Outer Space. But that is not to say that other actors did not deliberate upon or envision the potential for commercial exploitation. In fact, since the 60s, as Myers McDougall and others explain, they foresaw outer space as a myriad of resources of varying kinds, in which everything from solar radiation, magnetic and gravitational forces, wavelengths, geostationary locations, through to meteors tracking through the solar system, came to be conceptualized in terms of their ultimate value or utility. Even actors from the global south weighed in on this, though as articulated by Chris Van Eyck, the impact of this history is largely forgotten as we perceive space commercialization as a new thought. But while the Outer Space Treaty set forth that space and celestial bodies are free for exploration and use by all states in conformity with international law and subject to the condition that it be used for the benefit and in the interest of all countries, it prohibits ownership of the bodies themselves. It also qualifies that space activities by private entities must be authorized and supervised by the appropriate state. However, the treaty does not deal clearly with whether space resource extraction is a lawful enterprise under its terms. Namely, Article 2 of the Outer Space Treaty declares that outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. However, the term national appropriation is not defined in the treaty. The continued use and possible exploitation of resources was envisioned more directly under the Moon Agreement of 1979, which has not been ratified by any of the three major spacefaring countries, the US, Russia, and China. However, it does have 18 signatories and has been ratified by Australia and signed by France and India, which are not insignificant space exploring countries. It calls for establishment of an international regime to govern the exploitation of the natural resources of the moon as such exploitation is about to become feasible. The controversy is that Article 11 of the Moon Agreement provides that the moon and its natural resources shall be the common heritage of mankind. This common heritage of mankind concept, and in particular the lack of a clear definition of what it entails, and the fact that it might lead to mandatory benefit sharing, is perceived by many of the most significant, by many to be the most significant obstacle towards achieving widespread support for the Moon Agreement within the international community. But according to Hong, the non-space powers wanted to have a share of the fruits of space exploration and exploitation, and that state parties undertook in the Moon Agreement through Article 11.7 that there should be equitable sharing by all state parties in the benefits derived from these resources, whereby the interests and the needs of developing countries, as well as the efforts of those countries which have contributed either directly or indirectly to the exploration of the moon, shall be given special consideration. He argues that even if the value of the Moon Agreement per se is open to serious doubt, the tacit or express reaffirmation to the common interest principle by the two space parties and other countries during the entire process of negotiation can hardly be repudiated. He concludes, therefore, that the Moon Agreement is an existing international legal instrument which strengthens the force of the common benefit interest principle in Article 1 of the Outer Space Treaty. The future regime which the Moon Agreement anticipated is of course yet to materialize, and there is no clear understanding of how the sharing of benefits could be implemented in the context of exploiting natural resources from celestial bodies. But this does not mean that the Moon Agreement is dead, despite popular sentiment. Interesting to note that it was the United States itself, today's most vocal critic, that introduced the common heritage nomenclature into the Moon Agreement, so things can always evolve. These agreements were negotiated at the legal subcommittee of the Committee on the Peaceful Uses of Outer Space, COPUOS, but the forum arguably today has become less effective with respect to the progressive development of law, mainly due to political gridlocking, the requirement for consensus in decision-making, and the variety of interests competing for priority on their agenda. It may be noted that as of 2017, 4 of the last 5 items to be added to the agenda of the legal subcommittee dealt with general exchanges of information and views. According to DeMann, Professor DeMann, such discussions are generally not intended to result in new binding rules of international space law, or even in the multilateral clarification of existing principles. But Agenda 14 on general exchange of views on potential legal models for activities in the exploration, exploitation, and utilization of space resources is noteworthy, because at its 58th session, the legal subcommittee agreed to convene scheduled informal consultations on the issue of the exploration, exploitation, and utilization of space resources. The aim of those consultations was to have a broad and inclusive exchange of views on the future deliberations concerning the exploration, exploitation, and utilization of space resources, including the possible establishment of a working group under the relevant agenda item. Now, according to the International Institute of Space Law, whether the United States interpretation of Article 2 of the Outer Space Treaty is followed by other states will be central to the further understanding and development of the non-appropriation principle. At the 2021 session of the Legal Subcommittee, the moderator and vice moderator held 8 rounds of scheduled informal consultations. And the conclusion was that an official working group was confirmed following 4 more meetings at the main caucus plenary in August to September 2021, which finalized the mandate, work plan, terms of reference, and methods of work for this working group. Now, currently, the United States government owns 842 pounds of lunar material. There is little question that NASA and the US government considers this material, as well as other space materials collected by American astronauts, to be government artifacts. As highlighted by Pershing, NASA explicitly endorses US property rights over these moon rocks, stating that lunar material retrieved from the moon during the Apollo program is US governmental property. But as Brian Israel highlights, with the prospect of private space missions that go beyond what even governments have done in space, national legislatures have begun to wade into controversies over the interpretation and application of the Outer Space Treaty in parallel with or even ahead of international lawmaking processes. And in the US context, business actors lobbied legislatures to adopt domestic legislation that takes an aggressive interpretive position on whether mining and commercial exploitation of outer space materials is permitted under the treaty. As Professor Durkee highlights, this is interpretation aimed at a state response. So the United States adopted the Commercial Space Launch Competitiveness Act on the 25th of November, 2015, which seeks to address the foundations, if not the specifics, of these issues mentioned above. So it consists of 4 titles, and Title 4 is named Space Resource Exploration and Utilization, to be referred to as the Space Resource Exploration and Utilization Act of 2015. The provision establishes a basis for ownership of extracted space resources. This title contains provisions that recognize the property rights of US citizens in space resources derived from celestial bodies. So Section 402 states that a United States citizen engaged in commercial recovery of an asteroid resource or a space resources under this chapter shall be entitled to any asteroid resource or space resource obtained, including to possess, own, transport, use, and sell the asteroid resource obtained in accordance with applicable law, including the international obligations of the United States. So for the first time, this act makes provision for private property rights in space natural resources. While some applaud this legislative action designed to stimulate exploration and exploitation of space natural resources, others believe that the act is contrary to the provisions of Article 2 of the Outer Space Treaty. Because the term national appropriation is not defined in the treaty, it is possible to argue that the extraction or even the sale of space resources is not prohibited and is therefore already permitted, because the emphasis is on the resource extracted and not the land itself. So to diffuse the criticism of possible appropriation by the United States, the Act contains a disclaimer to the effect that by the enactment of the Act, the United States does not thereby assert sovereignty or sovereign or exclusive rights or jurisdiction over or the ownership of any celestial bodies. This is important as Article 27 of the Vienna Convention on the Law of Treaties provides that a state may not invoke the provisions of its internal law as justification for its failure to perform a treaty, and includes an ongoing obligation to bring its internal legislation in line with international obligations wherever a conflict may arise in the future. It remains to be seen if such a renunciation will be sufficient to satisfy those who believe that this US legislation constitutes an appropriation of celestial bodies. The 2016 session of the COPUOS witnessed a negative reaction to the act, but the acceleration of private space programs suggests that resistance to the interpretation has been ineffective. In fact, there is a slow emerging trend towards this interpretation, as evidenced by Luxembourg, the United Arab Emirates, and Japan enacting similar laws. This is important as it's argued that national legislation may be relied upon to clarify the meaning of an international provision. As highlighted by Mason Swan and Palfugitz, a national law such as the US law can be a possible interpretation of treaty law. However, it is not necessarily the only correct interpretation. Space practice will have to evolve further, and this can happen through the enactment of national legislation, but also by other means such as statements in COPUOS or responses to questionnaires of COPUOS working groups. The fact that states implement a treaty differently does not as such permit a conclusion about the legal relevance of these diversions. Such differences can reflect a disagreement over the one correct interpretation, but also a common understanding that the treaty permits a certain scope for the exercise of discretion in its implementation. This acceleration of private space programs suggests that resistance to the interpretation at best has been ineffective, or at worst shows a wanton disregard for dissenting thought. However, the US in some way can hide behind its wording to straddle all sides of the fence. As Israel points out, the act simply points back to the United States' international obligations without opining on the content of those obligations. Congress abstained from interpreting the treaty to expressly delineate the contours of permissible space resource utilization activities. It left this to the executive branch, which evaluates non-governmental space activities for conformity with the United States obligations through federal licensing processes. So what has the executive branch had to say? On April 6, 2020, President Donald Trump issued an executive order on encouraging international support for the recovery and use of space resources. And that executive order cites Article 4 of the US Commercial Space Launch Competitiveness Act as the authoritative basis for the executive order, but goes even further. The key points are that the United States supports the right of commercial recovery and use of space resources, is not a party to a moon agreement, and rejects the moon agreement as the basis for any space resources governance regime, rejects the notion that the moon agreement is reflective or expresses customary international law, repudiates the notion that space is a global commons, and will seek international support for the exploitation and use of space resources. So the executive order largely restates existing US policy and law, but goes further and is significant because a debatable legal position was clarified in an executive order. It could represent both state practice and evidence of a pino juris, which is the belief that an action was taken out of legal obligation, which has significance for any developing customary international law regarding space resources. As Wasser and Jobs point out, the United States and the Soviet Union were able to establish the basis of customary international law for their appropriation of extracted resources simply by asserting ownership over moon rocks they brought back from space. The executive action, however, did not perform a crucial step, which is to determine what the licensing process would be for private companies. As such, in the US, there is a regulatory gap for unprecedented on-orbit space activities like mining. The closest the US got to was in August 2016, when a private company, Moon Express, was authorized to land its robotic mission on the moon in 2017. The company's declared mission aimed to fly commercial missions to Earth's nearest neighbor and help exploit its resources. The novel step that the executive order did achieve, however, was to direct the State Department to lead interagency efforts to encourage other countries to adopt the US position that both public and private organizations have the right to use space resources. The order called for doing so through a series of bilateral or multilateral agreements. Here comes the Artemis Accords. They were therefore proposed in May 2020 and elaborated further in October 2020 by NASA as a series of bilateral executive political agreements between the United States and other countries that want to cooperate on the Artemis program. The memorandums of understanding, which have now been signed by 12 states, Australia, Brazil, Canada, Italy, Japan, Luxembourg, New Zealand, Korea, Ukraine, the United Arab Emirates, the United Kingdom, and the United States, set a normative framework based on the Outer Space Treaty that covers all kinds of activities involved with lunar exploration. Subsequent practice by states is considered an authentic means of interpretation, for it constitutes objective evidence of the understanding of parties as to the meaning of the treaty. As highlighted by Professor Deman, this suggests, according to the International Law Commission, that such subsequent agreement and practice of the parties are often, but not necessarily always, particularly important factors for the interpretation of treaties. The rights and duties expressed therein take the form of expectations rather than legally enforceable provisions. NASA highlights that the Accords follow the Outer Space Treaty, and they do so in regards to the sections on peaceful purposes, emergency assistance, registration of objects, transparency, and release of scientific data. However, the provisions in reference to space resources is worth illuminating, stating in Section 10 of the Artemis Accords that the signatories emphasize that the extraction and utilization of space resources, including any recovery from the surface or subsurface of the moon, Mars, comets, or asteroids, should be executed in a manner that complies with the Outer Space Treaty and in support of safe and sustainable space activities. The signatories affirm that the extraction of space resources does not inherently constitute national appropriation under Article 2 of the Outer Space Treaty, and that contracts and other legal instruments relating to space resources should be consistent with that treaty. Now, it is contended that the benefit of the Artemis Accords is that they are flexible and can respond quickly to change, unlike the treaty regime. However, others have argued that it is odd to see NASA attempting to define proper behavior in space on its own, and that NASA's action as a diplomatic surrogate for the United Nations is a significant and potentially harmful milestone in the commercialization of outer space. China and Russia are particularly notable absences from the Accords, and other notable absences such as Germany, France, and India are unsure of the merits of joining. While China has been largely silent, Russia has declared that the Artemis Accords are too US-centric, despite its discussions with the United States about participation in the Lunar Gateway, the orbital outpost of the Artemis program. But declared as a response to the US Artemis program, in March 2021, Russia's Roscosmos and China's National Space Administration, CNSA, announced a preliminary agreement to jointly develop a research facility known as the International Lunar Research Station. Statements from Roscosmos and CNSA underline that the project will be open to all interested countries and international partners. According to media reports, speaking at the Global Space Exploration Conference in St. Petersburg on June 16, 2021, Chinese and Russian space officials said that they were already in negotiations with international partners, including the European Space Agency, Thailand, the United Arab Emirates, and Saudi Arabia, to join their endeavor. As many states, including Germany, France, and India, have hesitated becoming signatories to the Artemis Accords, China and Russia are arguably leveraging this hesitancy to bring these states and others into cooperative agreements, which would, according to some commentators, challenge the future legal structures endorsed and based on the Artemis Accords. But would an Artemis Accords-like governance regime be developed as an alternative? The result would be diversity, in that there would be gradual emergence of numerous decision-making centers, producing numerous partially overlapping issue-specific regimes. This creates what we call a polycentric governance regime, a regime complex, and a fragmentation scenario as articulated by Dr. Tepper. But he and others argue that space governance is and should be moving towards polycentricity. Nevertheless, the appeal of using polycentricity thinking is hampered by the lack of clear principles for how to operationalize it. There are several examples of various attempts at cross-scale collaboration, but very few analyses analyzing the impact on governance. So polycentric governance also has challenges, including dealing with resolving political conflict and the potentially skewed benefits of common resources, but also so-called scale shopping, where groups dissatisfied with politics at one scale simply approach a more favorable political venue in which to frame their interests. This will only be addressed if there is a way for regimes or nodes to actually talk to each other and adopt what philosopher Kant has called the universal law of hospitality, in the name of which Professor Janda describes as a certain emancipatory justice that would unconditionally provide for and forgive the debts we owe each other. What seems clear is that all governance regimes that will be established will declare to have their foundation based on the Outer Space Treaty. Significant efforts are expended by US officials to communicate that US-led government instruments are not seen as replacing international instruments, with Section 10.4 of the Artemis Accords setting forth that the signatories intend to use their experience under the Accords to contribute to multilateral efforts to further develop international practices and rules applicable to the extraction and utilization of space resources, including through ongoing efforts at COPUOS. Now, coming at this from all angles, the latest innovation from NASA is in contracting and public-private partnership instruments, which has the effect of norm setting through private sector activities. So in September 2020, NASA announced that it would buy lunar soil obtained by commercial landers as a token purchase intended to set a precedent. So local and international companies selected for space resources contracts would collect a small amount of lunar soil from any location on the moon's surface and provide imagery to NASA of the collected material, along with data that identifies the collection location. After NASA receives the information, the company will conduct an in-place transfer of ownership of the lunar regolith to the agency, completing the commercial transaction. 80% of the payment is to be made on delivery. The payment is only a nominal amount, but the transfer of ownership and the act of selling something collected on the moon sets a precedent that an in-orbit transaction does not amount to appropriation. After ownership transfer, the collected material becomes the sole property of NASA for the agency's use under the Artemis program. So by December 3rd, 2020, NASA announced that the companies it had selected to collect these lunar resources. 22 proposals were received, but only 8 were eligible. And of those, 4 bids from Lunar Outpost in Golden, Colorado, iSpace Japan, iSpace Europe, and Masten Space Systems from California were successful, with contract awards ranging from just $1 to $15,000. The funding is so low because NASA is paying solely for the collected material without footing the bill for any of the company's development costs. NASA Administrator Bill Nelson presented the CEO of Colorado-based space startup Lunar Outpost with the first payment ever issued to a company as part of a space resource contract on August 23rd, 2021 at the Space Symposium. And this check was just 10 cents or 10% of the Lunar Outpost's $1 bid. Now, while the countries that these companies are registered in are all Artemis Accords signatories, it begs the question, if they had not been nationals of signatories, how would such action have bound their countries? After all, Article 6 of the Outer Space Treaty states that state parties to the treaty shall bear international responsibility for national activities in outer space. According to Professor Durkee, when space companies launch, extract, and sell outer space resources, they force their home states and others into a reactive posture, increasing the likelihood that their chosen legal principles will prevail and harden into law. The space law case study, therefore, shows how private actors can force the development of uncodified international law on 2 levels, on a doctrinal level and on a realpolitik level. So the contracting approach also raises a number of significant governance questions. To start with, how will NASA verify a contract that has been fulfilled by photographs? And how will they ensure that the collected material remains in their possession after the images have been taken? And how will the lunar resources be managed, considering sustainability and stewardship? Well, one nonprofit organization has launched a project to answer some of these questions. On the heels of the NASA announcement of the awards, the California-based Open Lunar Foundation has established a perpetual purpose lunar resources trust that they call Broken Ground, which intends to steward and demonstrate formal and effective institutional management of lunar resources between different stakeholders. The trust will be governed by a committee that the foundation says will operationalize efforts, including the purchasing of lunar regolith, facilitating participatory consultative processes to involve many stakeholders in determining, identifying, and advocating for clear new resource management regimes as a result of these efforts. Further, the trust seeks to make multiple purchases, which may each explore different management treatments. In essence, it conceived of the idea to pursue the same contracts as NASA, except that the purchases would be held in trust rather than by the government. The resulting rights and interests would then be assessed by experts and civil society with the aim of maturing the bundle of rights frameworks for the moon. In December 2021, Breaking Trust 2020, Breaking Trust signed its first memorandum of understanding with Intuitive Mechanics, a provider and supplier of space products and services. While this trust is a laudable initiative because of its focus on stewardship, it is worth noting that this initiative is encouraged by the United States as a further buttress for their intentions and does nothing to address the main challenge to the US position on space resource exploitation. That main civil society challenge is aptly expressed in a recent article published in Science by University of British Columbia professors Aaron Bowley and Michael Byers, who argue that promoting national regulation of space mining rather than multilateral governance risks a race to the bottom, and that because acquiescence is often treated as consent in international law, even NASA's purchase of lunar soil would, if not protested by other nations, strengthen the US's interpretation. Case law of the International Court of Justice and other courts applying the Vienna Convention on the Law of Treaties confirmed that the acceptance of practice by other states can be brought about by silence or omission. As highlighted by Professor Durkee, interpretive entrepreneurship can lead to formal or informal entrenchment of the entrepreneurial interpretation. So they argue that NASA's actions must be seen for what they are, a concerted strategic effort to redirect International Space Corporation in favor of short-term US commercial interests with little regard of the risks involved. Tobin observed that interpretation is ultimately an act of persuasion, an attempt to persuade the relevant interpretive community that a particular interpretation is the most appropriate means to adopt. Thus, Bowley and Bias have continued their advocacy and led an effort in August 2020 to ask the United Nations to draft an international treaty that would set uniform rules. They sent a letter asking the United Nations General Assembly President Tijani Muhammad Bandi to seek a resolution that would initiate multilateral negotiations. And it was endorsed by more than 140 scientists, former politicians, and diplomats. Shared understandings within communities determine whether an interpretation succeeds. However, an interpretive community populated by advocacy networks, legal academics, and other organizations may offer a different interpretation than an interpretive community populated by states. Does this matter? Is this a case where all voices need to be heard, whether governmental or non-governmental, national or international, technological capable or aspirant? But it's also important to ask, will there be a conflict of interest issue if private interpreters are competing with sovereigns or displacing authoritative interpretations? Climate change serves as an interesting case study in this issue. So in conclusion, it seems that space lawmaking is at a crossroads. Clearly, the United States has set in motion a series of initiatives that have moved the dialogue along at a pace that supersedes that of the multilateral process. When national legislation is being pursued at the same time that proceedings at the intergovernmental level appear stagnated, the danger for modification through state conduct becomes real. But Finn Robson's prediction that the future of space governance is increasingly less international, characterized by coercion, coalition building, and the pursuit of hegemony need not be so. But to act on this consensus building is also a security imperative. Lee Foster and Namrata Goswami warn that state behavior in other areas beyond national jurisdiction is a cause for concern and shows us what could happen if states continue with a first come, first served scramble for the skies mentality rather than see space as a global commons for humanity. The absence of a centralized authoritative mechanism for adjudicating divergent interpretation suggests that there will be more variability in national processes. But with the new administration in the US as of January 20th, 2021, and all the delays recorded, the 2024 politically motivated goals set for the Artemis moon landing will not be reached. So moving at the speed of light is no longer necessary. As such, as it may chafe the spirit of innovation, time must be taken so that diverging views are heard and stakeholders consulted to determine a multilateral approach, while still ensuring that the momentum gathered from the preceding 5 years of action is not wasted. While there is some legal uncertainty surrounding the field, consensus does seem to be growing among spacefaring nations that commercial resource exploitation is compliant with international law. And there is a lot of promise for this new COPUOS working group to gain some consensus. But as highlighted by Anderson et al., based on the decision-making process for earthbound mine development, it is likely that space mining companies and their investment partners are likely to require a more sophisticated and complete legal and commercial structure before committing to a space mining venture. After all, the two companies instrumental in driving the US regime are no longer in existence. But using the US example to express how the diversification of space actors affects governance, non-state actors' influences have been significant, acting as norm and interpretive entrepreneurs, and using nudging or forcing behavior as one amongst a suite of tools to push entrepreneurial interpretations of existing law, fighting the interpretive battle in Congress and the court of public opinion by advancing a business model on the prospect of legal change and then pushing for that change. This is important because in a world where financial power can translate into persuasive power, frequently located in the global north and in the private sector, the meanings that stick might be the meanings backed by capital, which are also the meanings that entrench capital. What is clear is that the legitimacy and fairness of international law will be judged first by the degree to which the rules satisfy the participation's expectations of justifiable distribution of costs and benefits, and secondly, by the extent to which the rules are made and applied in accordance with what the participants perceive as rights process. It is required, therefore, to identify that core of the shared assumptions about fairness, or more exactly unfairness, which once identified and agreed upon will enable the community to embark on a fairness discourse and to proceed with negotiations which address specific allocation problems. As stakeholders in the evolving global governance regime, we have two tasks. First, we must protect outer space from claims of sovereignty and their unequitable exploitation by individual states and their nationals. And second, we need to protect the interests of future generations in these resources. To be successful in either task, we must first create a sensible working relationship between international and national laws. Thank you.
Thank you so much, Professor Timiebi. So many things to wrap one's head around. Yeah, well, so let's start with it. So I'm passing the mic to my colleague, Marina Masinova, so she can facilitate the Q&A. Marina.
Thank you. Hello, I'm Medina. Thank you, Professor Aganaba. We have some questions in the chat, so I will read one of them to get started. Yanis asked, is there international treaties that has dealt with the ramifications and consequences of colonialism, and can we use the colonial angle for outer space? What insights can we apply to outer space from the history, but also the legal frameworks that dealt with colonialism?
That is interesting. And I didn't talk about it in my talk which was the talk that you all saw was titled about being in the space 5.0. And what I meant by that is actually, I think that this era of space exploration has to look at the non-technical issues. You know, all the other eras of space, the space 1.0 era was about astronomy. The space 2.0 era was about the Apollo landing. Space 3.0 was, you know, they were about the moon landings or about International Space Station. And now we're at this standpoint where we have to look at the social dimensions of all the activities, which means looking at the history, which means looking at the social context in which technologies actually live and operate. So what we see is that, for instance, during Apollo, there was the civil rights movement going on in the US where people were looking for emancipation. And today, you know, when, I don't know if you guys were following the Virgin Galactic and Blue Origin, you know, commercial space flight, they were on the backdrop of the Black Lives Matter movement. So, you know, we can't detach the context of society from these technological experiences. But I think now we're at the point where we say the barriers to space exploration and exploitation are no longer technological. The technology is kind of easy to fix. The issue is, how do you figure out the social dimensions, especially when we start talking about humans going and living and working in space and us becoming a multi-planetary species? Then the role of the individual and their personal experiences are going to be increasingly ever more important. So I think that there are a lot of lessons that we can learn from, you know, the decolonial movement, and the fact that we don't want to take all these things up into space. And one of the problems that we have in the space context is that people think that, well, that doesn't matter in space because there are no victims, there's no one in space to colonize, it's just virgin territory. But what we have to remember, the spirit of coloniality teaches us that during colonialism, the settlers also believed that there were no victims because they didn't see the indigenous people as people. They didn't see them as anything that they were going to destroy. So maybe in space, we don't know if it's going to be the same in the future, where right now we say there's no victim, there's no one in space, but we've said that before. So we have to take the lessons learned, and we have to say we need to go into space with a sustainability mindset, which means from day one, learning the lessons of history. I hope that addresses that question.
Thank you. And we have questions from Tamara. Would you like Tamara to read them out loud?
Well, she can't activate her mic.
Yes, okay.
I think you can hear me now.
Yes.
Oh, yes.
Okay,
Yes.
so yeah, sorry, I have several questions. So I don't want to, okay, so the first one is, do you know if any UN copious delegation planning to protest the US's interpretation? And the other was, in what ways does the Russia-China approach differ from the Artemis Accords? And then I had a last one, do you see a new Bogota declaration coming from nations of the global south, asking for a more equitable, I guess, distribution of space resources or the benefits of the space resources? Thank you.
Great question.
That was a great talk. Thank you.
Yeah, those were fabulous questions. I think, the thing is, in international relations and international law, sometimes people hold entrenched positions. Like, even if, for instance, I think the Artemis Accords is not that bad, but just from the fact that it comes from the US and it's a unilateral kind of like US saying we want to be leaders, you're of course going to have Russia saying we disagree with that, this is a US approach. And other actors, there are 18 signatories to the Moon Agreement who believe that we should have an international regime that's already set, or that we can build upon, rather than having these new multilateral, unilateral processes. So there are going to be people who are going to say that. But at the end of the day, when we look at state practice, we're going to look at who are the most interested states, who are the ones who actually can go to space and actually exploit space resources. And they're probably the ones who are going to make state practice. Because if we look at the Bogota Declaration, at the end of the day, the Bogota Declaration was a bunch of countries saying that the geostationary orbit, which is a limited resource, 36,000 kilometers from Earth, which is over the equatorial regions, that should be part of their territory. Now, if that territory had been over the US, I believe there's no doubt they would have said the same thing. But at the end of the day, those weaker countries, they had no power to utilize that right that they were trying to get. So it would be very difficult to get the rest of the world or the developed countries who had the power to utilize to agree with their interpretation. So, but I do see a role for, non-classic actors, because I started my career in Africa, the Nigerian Space Agency. And now we're going to have an African space agency that's, even though we have 20 countries in Africa that have space programs, we're going to have an Africa-wide space agency by 2023. And I think that is going to be the emergence of a new multilateral, like a huge player, because even if Africa is not advanced technologically, they could do a Bogota Declaration type thing, which would have to be listened to in today's context, you know, so in light of everything that's going on. So I think I have a lot of hope for the future, that we're in this, you know, future lawmaking environment where different perspectives are coming to the table, and it's no longer the domain of just a few actors. So they're gonna have to listen.
Thank you. I think there is a question from Yanis, but first, does anyone else have questions? Oh, I think Catherine, maybe we can proceed to her.
Yes, hi. Thank you so much for that brilliant and informative talk. I'll try to compose my thoughts, but it's you had language that was so evocative to me about regulatory gaps, about resources, about appropriations. And I wanted to think about like what constitutes an outer space resource. So specific, I mean, if I can understand that's like a matter of legal specificity. That doesn't like necessarily hold up philosophically or something, like everything is a cosmic resource, right? But specifically, I'm thinking about the stages you laid out, that like you said, astronomy is stage 1, and then there are some, and then 2 other stages. But I wanted to think about the way that astronomy is looping back
Yes.
to our contemporary, and specifically through astronomical data, right? So astronomical data is big data, it is complex data, it is valuable data, and it's being appropriated, right, by Amazon, by Google, by national governments as a proving ground for AI. For earthly governance, for the development of algorithms that optimize and automate and track and surveil, and this is not this is to me a regulatory gap, right? So what do we make of cosmic resources like light, like observation, right, that get registered in an earthly fashion as astrodata, as astronomical data, as the biggest big data, and then appropriated for AI, for governance, for the optimization of logistical capitalism? How do we think about that regulatory gap and that form of mining, right? And yeah, I guess I'll leave it there, but I wonder if sometimes in our like very grounded and deserved turn toward materiality, we've lost track of the way that this ephemerality becomes concrete and becomes governance as well. And is there, I mean, as a matter of like just curiosity, is there any regulation on what astro data can be used for in terms of AI particularly?
Wow. You have challenged me with that fabulous question. I mean, what is a resource? I mean, the funny thing is we're still at the point, so I'm in a working group for, you know, on international law, talking about, is astronomy even a space activity? Because, I mean, it feels logical that it's a space activity, but there's nothing about ground-based astronomy that actually is space. When you think about the fact that most things in space mean that you have to get to space. And that just reminds me of, you know, that discussion of like them trying to justify that astronomy deserves the legal protections of a space activity, not so that we don't say that Elon Musk's, you know, internet broadband thing is like overriding or is more important than astronomy. But if astronomy is not even a space activity, the space community don't have to think about it. So you just raise a fascinating question as to what is a resource? And like, you know, right now we talk about resources as, you know, like mining and getting water. So the big resource in space right now is water. Because if we get water, we break it down into hydrogen and oxygen, and we have oxygen that we can breathe and hydrogen that we can use as fuel to be able to move around the solar system. So that is like the mega resource. But like one of my colleagues, Chris Van Eyck, talks about the fact that low Earth orbit, the orbits are a huge resource that is something that we even care about today. And like the fact that SpaceX were able to get licenses for like something like 40,000 satellites, that's a strategic resource. Even if they don't launch 40,000 satellites, they've already got the resource to be able to communicate with those satellites, which is a limited resource that is actually shared globally. So one company has got more access to those resources than like a whole bunch of countries all combined. So you know, so yes, this brings us to the question of always saying, what is a resource and who is a resource relevant to? And when does it become relevant to that particular actor? Because for instance, I have this big problem in the African context, because it's like, why should Africa care about moon exploitation? They have so many things to worry about. But I'm like, at the end of the day, if we look at history, if you don't start off at the beginning of the conversation talking about how things are going to get carved up, you will never be part of that conversation. Like they're not going to later be like, oh, we'll invite you to like talk about it. Like once you're not there at the beginning, you're not there. So even if, so in the African context, they may not think that, you know, water on the moon is something important to them because they're addressing more things. And I'm like, no, you have to realize that this is going to become important. And so you've got to be there in the beginning of the conversation. So everything that you're saying about the whole AI thing, it's the same kind of story. Like, even if we don't see a particular thing as a resource right now, it's gonna, we've set up space forces to defend these assets. So that means that some people really see them as valuable. So we have to think about it. You know, what are your thoughts?
Well, I'd love to respond. Thank you. I'm so enlivened by this conversation. It's such a pleasure to talk to someone so informed and thinking so critically. So in the case of astrodata, if we use it as an example of like a space resource that seems a little ambiguous, you know, but it's not all that ambiguous to Amazon. They're like, oh, that's a whole bunch of free data. It's hard to come by 40 terabytes of free data. So what I wanted to what I wanted to ask you about was, in my research, what I've learned is that what makes this astrodata so easily appropriable is its construction as free. It's not, there's no privacy constraints. There's no sensitive geophysical data about like natural resources. It's not proprietary. It's not constrained by privacy law. But more importantly, in my imagination, what we mean by free astrodata is the liberal construction of the cosmos as commons. And so I was curious, you mentioned this, you had this interesting way of working with Kant, right? And that like the cosmos or something is like a way of absolving our debts. And I experimentally want to ask if like, what would it mean to talk about astrodata as like not free, but a site of immense obligation? Right?
Yeah. So
like,
sorry, I didn't mean to cut you off, but like one of my best friends did her PhD on, so Copernicus, which is the European Earth observation program, has a free and open data policy. But when you look into it, like when I talk to my African counterparts and they tell me it's not actually free. they're using the language of free to be like, we're doing this thing that the whole world benefits from, but it's not, there are constraints to what is free. And so that means it's left to the individual to determine, what does openness and freedom actually mean? It seems that it's okay to just use it, because so long as you're not paying, you can use the words open and free, but that can mean whatever it wants to mean, you know? And so she made me understand that just because someone says a word such as open or free doesn't mean that it is.
Which comes to this question of universal heritage or universal commons. And like a lot gets, as you have so detailed, so much gets masked under that framework of universal access or the universal commons, right?
Yeah, and like, you know, I did my PhD was titled Cosmopolitan Approaches to International Law, and I battled with it because I started off with a third world approaches to international law approach, like trying to look at third world perspectives to look at governance. And for me, I found that I think it marginalizes, because people are like, third world approach, that's too critical. And at the end of the day, you have to work with the establishment. So if you're being like overly critical, you know, I don't know how far you're going to get. And so I was like, a cosmopolitan approach. And I'm like trying to be a middle ground person and trying to bring everyone to the table. I mean, third world people would hate my perspective, because they're like, you're just playing to the big guys by just trying to be nice and trying to be friendly. But for me, I think, you know, there is a role for dissent and there is a role for being aggressive. It just doesn't seem to have worked very well for us. And so when I took the cosmopolitan approach, you know, people were like, but the funny thing is, all these different approaches that you take are still rooted in hegemony and still rooted in all these unfair practices, whatever ones you take. And so it's very incumbent upon us, or upon people who want a new birth, or like for me, like why I am hedging my bets on Africa and just being like, just let us know something that is original to where you're coming from, because everything else is completely rooted in all these historical practices. And so we definitely need some new approaches that we can look at that are more aligned towards what is for the benefit of all mankind or humanity. And maybe for me, I feel like looking towards Africa, if you can cater to the needs of that African girl in Botswana, you really will have catered to the needs of the world.
Thank you. I hope this answers to your question, Catherine. We also, does anyone else has questions?
Yes, I have a question as well.
Mm-hmm.
My question mainly relates to questions about modeling potential gain of resources and what that might look like over time. The analog that comes to mind when I think about you know, claiming natural resources, we don't know how many, we don't know how much, are specifically like water rights, and like the complexities of that issue as they played out in the Midwest, in the West, in the United States, and how there are a number of states currently that are fighting over water rights to maintain their cities and their populations using figures basically that were drawn up during flood years. So essentially, like, there's like a complicated network of real property claims on water, and just I'm thinking about like untangling that in space. So like, you know, you create a framework for a certain amount of resources that you think might exist, and that doesn't really determine, like, you know, what happens after 50 years of mining. It's just, it like, my big question is like, is there any ideas on how one might model that kind of change over time?
What a fascinating question. What a fascinating question, Josh. I don't know. I really don't know. And I think we're still at the point where we're trying to map out what resources exist. So at ASU, one of the exciting things that we're doing is that we are the PI, the principal investigator for the Psyche mission, which is launching next year, which is the first mission to a metallic asteroid, an asteroid made of metals, where we're going to go there and we're going to figure out the chemical composition of this asteroid. And that's just going to be fascinating because it's supposed to be worth trillions of dollars or something like that, but no one has ever characterized what these things are worth. And so the first step is really knowing what resources are there. But I think at the background, we have to start saying, and I think that we have to start thinking, okay, well, what is the next step? If there are a bunch of resources, is it because ASU were the first ones to characterize it that we have some kind of claim over it? Is it that, is it, how do we make that information accessible, and which actor gets to go there first and take advantage of this information? Right? So like, there's a whole bunch of stuff, but first step is like just knowing, because right now we're just speculating about what resources there are and figuring out the technology. But once I'm like nervous about what happens when we get to the asteroid. What if we get there and it's literally like, okay, this thing is worth trillions of dollars. There's like gold and there's like leprechauns and unicorns and everything on there. What do we actually do? Then we have to get serious about figuring out that, what does that mean? Who do those resources belong to? How do we need to have a benefit sharing regime? Do we need to figure out that? I don't know. I really don't know. But you ask a fascinating question. Josh, do you have any thoughts about it? Like answering your own question?
Well, I mean, my thought was that basically it would make a lot of sense to look to sorts of like what's the word I'm looking for? Tragedy of the commons type situations that have happened in the past, and sort of look at them as sort of fuel for, figuring out a decision-making process to just to equitably allocate these resources in the future. So sort of like sitting down, looking at the way that water rights have been broken down in California and saying, it's like, okay, so this is how they were created, and like these are the entities that have benefited disproportionately, and these are the entities that have basically been shafted, and sort of like use that as a template to say, all right, this is what's happened in the past, what worked, what hasn't, and how do we incorporate that when we create this new construct.
Yeah, that's really useful. That's really useful.
Anyone wants to ask questions? Yeah, I think Yanis has questions, so passing mic to you.
Yes, apologies for the low light here. Thank you very much for the talk, and also the fellow attendees for the discussion. It's very fruitful. The tragedy of the commons, I think one way that we can bring environmental thinking into space is the big issue of space debris, in other words, space pollution, where there have been all these missions that kind of have not gone anywhere, and then they've left orbiting objects around the Earth. And that's actually problematic because it makes harder and harder, the more debris we create up there, to actually launch successful missions out of the Earth. So that's an environmental aspect of the space, which I would be curious to see if it's ever been incorporated. So space junk is one question I have. the second question goes back to the whole premise of why do we need a special treaty for outer space? Why can't we apply concepts that we already have? Others, like terra nullius, for example. Does terra nullius apply to outer space, or terra nullius is considered to be literally applying only to Terra, in other words, to Earth? That's the second question. And the third question, I want to wait a little bit because it has to do again with how we arbitrate value. And of course, it's nice to say that, you know, the space is a commons and the resources there are common property, which is not really the case, because in order to access that common resource, you know, somebody has to put the infrastructure, the know-how, and a deployment to get there. The same applies to water. Like people think, oh, we are paying for water. No, you're not paying for water. You're paying for the infrastructure. Because without the infrastructure, you cannot get to the free resource, which belongs to everyone equally, which is water. And that's a big issue. And I want to ask you if you know more details about how did NASA negotiate the prices with these prospectors, these bids. They have these RFPs, the 22 that only 8 were approved and only 4 were actually NASA paid. NASA only said, you said it only pays for the rocks. It doesn't want to pay for the equipment, the infrastructure, you know, all of that will get the rocks. So I'm curious, how did they negotiate the economics of that with those companies?
Yeah, you asked some fabulous questions, Yanis. First of all, space debris, environmental law. So I did my postdoc in environmental law because I realized that the best analogy for space was really environment. I think that the lessons learned from the environmental movement are really what we need to make us be able to think sustainably about how we go into space. And definitely space debris is the biggest environmental issue in the space context. And I think that, you know, just the way, even though people know the right thing to do on Earth, they're not doing it with respect to climate change. It's kind of the same in space in that it's just like we've been operating in space for 50 years without thinking about the environment and about space junk, right? And so you've got this challenge that like you're going to have to change people's practices, and then the newcomers are going to say, well, the old comers never had to worry about that, so why should we have to worry about that? You know, you have all these things that are not logical but come into play. And so we talk about, you know, for instance, even should we be doing cleanup? So get rid of some of the debris so that we have less risk of kind of collision, but then it comes down to who's going to pay for it. And when you do have these collection action problem where a whole bunch of people contributed to the problem, the question becomes who's going to take responsibility to kind of solve the problem. And then it always comes down to we've got to find a market solution, because, you know, just being responsible doesn't cut it, because people still say that space is big. And not only is space big, the players can chat amongst themselves and figure out how to make sure they don't get hurt, you know? And so it's kind of really challenging. With respect to you, I mean, it's that whole contracting thing. And the reason that I talk about it is that it blew my mind. It was so strange. And it was so fascinating and interesting to be like, we're just going to go ahead and purchase these contracts and just see what the market is willing to bear. And, you know, the example that I gave of Lunar Outpost, their bid was $1. And at Space Symposium 10 days ago, NASA gave them a check for 10 cents. So, but they already have a NASA contract for something else. So this is just an additional thing to figure out how can you collect the moon rocks and put them somewhere. You don't actually have to bring them to NASA. So we haven't figured out, like, so you just have to send a photo, a picture of where you've put them. So all this is meant to do is set a legal precedent that there is a market and a contract can be negotiated. Even if the value is only $1, in economic terms, $1 is still value, right? And the biggest one was $15,000. So, the questions that I ask is, how are they going to validate the contract that actually happened? Like, and then what happened is that Open Lunar Foundation did that trust that now said, okay, we'll do the same thing. We will pay people. If people are willing to do it for $1, we will also pay people and see if we can hold these resources in trust and figure out how can we think of a sustainability mechanism based on the resources that we now own through this trust. So a whole bunch of, that's the exciting thing about space, right? These innovations and just the ability to be able to innovate is just phenomenal, which is why for me, I'm just like hedging my bets that Africa should come up with its own version of one of these innovations, right? To just be like, let's test something out, because it seems that we're in the time frame in space governance where we're at a turning point where we can make these proposals about governance, and it can play back out on Earth, because if we're able to use space as an experiment ground for being able to do things differently, why not take the best practices and bring them back down to Earth? What do you think, Yanis?
I think I think it's unfortunate. I think the cooperative invitations model that Russia and China are doing is the best avenue for countries that do not have by themselves the means to independently launch their own missions, to actually get in that space and exert some influence and offer like fresh ideas and practices. So I'm going with the Russia-China approach, not because I'm with Russia and China, but because I think their approach to be more cooperative and invite inclusion, as opposed to the US, which is really looks like it wants to set out its own stakes and assert its own interests, which are not really the interests of the United States. I mean, if you really think about it, there is an internal colonialism within the United States as well. I mean, it's the few people that, some are government, some are corporate, some are, connected with them, that will benefit from this space exploration endeavor. And as much as they can pontificate that is for the good of humanity and we're pushing the frontier, sure, the frontier of knowledge is pushed, but that frontier is not accessible to all humanity. So it's only theoretical that the whole humanity benefits.
Right.
And that benefit will actually trickle, even a drop to, let's say every human being, besides just being elated that a fellow human being was able to achieve what has been achieved. But I think the space exploration is way more serious than we think about it, because regardless, this is not an immediate need for humanity, but eventually, the sun is gonna grow to be a red giant, and actually is gonna make Earth uninhabitable. I mean, we're talking in millions of years. However, humanity should, it's never too early to start thinking about relocating. It's not going to happen in 100 years or 500 years, but we have to start that process now. And so we have to figure out how to do that, because that actually is going to be a matter of survival. Who can relocate themselves further, like going into Mars, developing an atmosphere in Mars? That's of paramount importance for species survival. I mean, it's not a joke. It's not as, it's the moon, and what, we don't care about the moon. We have the Earth. We have plenty here. I mean, we do have plenty here, but it's the importance of space is about species survival and developing the know-how of how to make other spaces, other places in outer space inhabitable.
Yeah, I mean, today I've been on the phone with NPR, with the New York Times. Everyone's talking about the Inspiration 4 mission that's coming up. I don't know if you guys know, SpaceX next mission coming up, I think in 10 days or something, with like civilians, commercial astronauts. And it's just like the narrative has always been, and is really like space is for all. It's always been that narrative, but like, what does that even actually mean? And what we saw from the Richard Branson and Jeff Bezos flights was that the general public don't buy it, right? Like everyone was just saying, oh, it's a bunch of billionaires just messing around in space while like we're all dying here of climate change. They're thinking about running away to space, right? Like, as much as we say that space is just so, it does ignite the imagination of people, but it's like people are mixed about how they feel about it. So yeah, Catherine, you have your hand up.
I did, didn't I? I had it up and down a few times. Yeah, I was just gonna say, you know, in like picking up on Giannis, but pushing back a little bit, like, to me, this question of the geopolitics, like who's doing it right? China, Russia, the US, like, it doesn't feel like the only question. It's like, to me, it's more, and again, to Giannis, like, this is what humanity has to do. Well, hang on a second. What do we mean here? What do we mean by humanity? What are the politics embedded in this assumption that this is what we have to do? Who are we talking for? You know, and like, I guess I'm just curious in obliterating the cosmos as the elsewhere and as the otherwise, and like, but also like recuperating a more radical politics of the commons around the cosmos. But for me, I'm like, that's an earthbound politics, right? It would be maybe like materially through the production of dark skies. Like, what do you need to see the cosmos? I guess you need autonomous zones free from industrial pollution, and you need affordable housing, and you need to like not be threatened by the police, right? Like, can we radicalize the cosmos? Not sit with this liberal futurism of humanity's escape from itself, undefined humanity, or like implicitly defined humanity, you know? Like, I don't mean to be combative. I just want to.
No, not at all. Because the funny thing for me is with this whole escapism, I'm like at a mixed minds as to who's going, because the only people that can go are the billionaires. But if we look at history, you're not going to send the wealthiest people to this hostile, unexplored environment. You're going to send like the little guy who's like, yeah, you're going to send the little guy, exactly, that has no rights, and push him up there and let him die. and so it's weird because this narrative of like Elon Musk's of like, let's go to Mars, who's going to Mars? And when I see Mars One, like this mission which has the first people that said they wanted to go on a one-way trip to Mars, I was like, are their faculties all there? Like, who at this point is going to take a one-way mission to Mars? Like, really? In that hostile environment where we haven't figured anything out, and people are saying that they would get a one-way ticket.
Yeah, I was like, that's some incel shit. Like, you're really mad. You're really, really mad. Okay, got it. But, like, you know, again, exactly, I'm with you, and to push back on Giannis, this is not what we need to do to survive. We need to, like, actually not do this if we want to survive as anything deserving of the name humanity, in my opinion. And I don't mean, like, we can't colonize space because it's reproducing colonialism. I'm like, we cannot continue to operate with this language. Actually, like, we can do activities, but we need to stop thinking that we are saving humanity with, like, no actual consciousness of what we're talking about. And we need to be a little more radical in our, like, literally, we live in the cosmos already. I'm not wrong, right? We live in space already.
Right, exactly.
And differentially, I would add.
To very much echo the sentiment, it seems like with the current tack that American policy towards space is going, it seems like we are on track for Elon Musk's children to own a mining colony on Mars and all of Mars by default, and Jeff Bezos's kid will have ads for Amazon etched into the surface of the moon. Like that feels like where we're going right now with the way that policy is being implemented.
Thank you for the questions. And I think we can, if there are no more questions, we have 5 minutes. But if not, we can conclude the event.
So somebody asked whether the paper would be available, and so I want to send it out for publication, and I would love whoever is interested in reading it and commenting on it to get some insights. You guys have great insights, and it's, you know, so if I don't know who can facilitate that, but anybody who would be able to comment on it, I would be happy to send it to you before I send it off to be published.
I put my mail in the chat if you want to share. I don't know if the organizers can send it to all the attendees, but
Yes, we will do that.
Yeah, if you want to put your emails.
Maybe we can share it through email according to the list of attendees.
Okay.
Okay. Any more questions?
Well, this was fantastic. I spent all day working on this. I was so looking forward to this conversation, and you know, you guys asked some great questions, and it was just my honor to talk to you. Thank you so much for taking time out of your busy day to come listen to me postulate.
Thank you, Professor Aganaba, for your time and sharing your research with us. And we'll upload the recordings to the YouTube in the coming days and post in the social media. Thank you, everyone, for coming.
Great. Thank you.
Thank you, Professor Aganaba. Great talk.
Okay. Stopping